India's Supreme Court has rejected a bid by the Swiss drug company Novartis to patent what it says is a new version of its cancer drug. Now, the ruling clears the way for Indian companies to continue copying the medicine and sell it cheaper. Now, Novartis was challenging the Indian government in a patent case to demand protection against Indian companies from copying its drugs. Under Indian law, drug companies cannot get patents on drugs that aren't radically different from other medicines. India is often dubbed the pharmacy of the developing world because it produces up to 90% of generic medicine on the global market and makes $12 billion a year doing so. Well, let's now get the latest from Sohail Raman, who is live for us in New Delhi. So, Sohail, the interesting thing about this is that Novartis has managed to patent the drug in 40 other countries, including China. So what was the Supreme Court saying, or what grounds are they saying that they are rejecting this patent?
Well, it's a very complicated case that's been fought over for 7 years in the Indian courts and landed at the Supreme Court's foot a year ago. Now, it all really pivots around the year 2005. Any drug that was patented before 2005 is respected by the Indian courts. However, Novartis wanted to patent the original Gleevec drug in 2006. That was thrown out, primarily because the Indian pharmaceutical companies were already copying that drug, you might say, and therefore it was seen as not a new drug coming in on the market. So Novartis went away. They then came up with imatinib mesylate, which is another form of the Gleevec drug, marketed under the same name, and they tried then to patent that. If they had succeeded in patenting that drug, then it would have reduced the level at which pharmaceutical companies here in India could have made those generic drugs a much cheaper alternative for millions of Indians and even many more millions globally. So what has really happened is that the Supreme Court has said that this drug, imatinib mesylate, marketed as Gleevec, is nothing new. It's still the old Gleevec drug that they threw out of court in 2006, and therefore they don't have a case to answer. Well, obviously now it's in the realms of the lawyers and the World Trade Organization as to how to deal with this, but it's a huge relief certainly for many low-income families here in India who would normally expect to buy the original drug at maybe $1,800 per month. They have a...
Exactly. So that's what I want to get back to you on. You know, I'd imagine this sets a benchmark in several intellectual property disputes. And what does this mean now in the wider context when it comes to the pharma industry and Indian patients?
Well, I think the context is that Indian pharmaceutical companies do manage to make generic drugs for the Indian market, as well as many third world countries, a lot in South Asia, Africa, Central America, and it's a huge market, as you mentioned just before you came to me, worth billions of dollars. But it's about getting drugs to those people that really need it, that can't afford the original drug that would be normally marketed in North America or Europe, and make it affordable to families who, for example, may only have a monthly income of $120 when the original drug, in this particular case, Gleevec, can cost as much as $1,800. It's a huge difference. It's 18 times more than what they would normally pay, and so therefore this verdict itself brings a huge sigh of relief to millions of certainly Indians here who depend on the generic form of Gleevec to survive and prolong their lives.